topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Well, good afternoon. Bill Martinez here. Great to have you with us, sharing a part of your day. For more information on the show, you can check it out, BillMartinezShow.com. Our next guest, he and his partner, John Yoo, have come together to write the Politically Incorrect Guide to the Supreme Court. You know, presidents come and go, but the Supreme Court goes on forever. So says William Howard Taft. Robert Delahunty, welcome to the show. Good to have you with us, sir.
Thank you, Bill. It's an honor to be here. I'm grateful that you let me chat with you and your audience.
Well, this is in light of all the conversation about the Supreme Court these days. The book has a little edge to it, which is fine, and I think that's the title, The Politically Incorrect Guide to the Supreme Court. But there's a serious side of the Supreme Court, so maybe let's delve into that to begin with. Robert, is the origins of the Supreme Court, and according to the Constitution, what are its specific duties?
We wrote this book for to be user-friendly and to reach a very broad audience. We think that a lot of people are interested in the workings and the history of the U.S. Supreme Court. And so we wanted a user-friendly guide that would still be, legally fairly sophisticated, not just for lawyers, but for the general public. And the United States Supreme Court obviously plays a very important role in our society and in our system of government. In some ways, it's a uniquely American experiment. The Constitution, in its third article, provides that there shall be a Supreme Court. It doesn't mention whether there are going to be lower federal courts. It leaves that to Congress, but there shall be a Supreme Court. And it was fairly early on decided by the Supreme Court in 1803 in a major case called Marbury v. Madison that the court had the power to review acts of Congress and determine if they squared up with the Constitution. And if they didn't, the court said it had the power to strike those acts of Congress down, to invalidate them, to make them void and unenforceable. That's an enormous power. And it really hasn't been seriously challenged since 1803. It is in the Constitution, not expressly, not in so many words, but by implication.
Yeah, exactly. Well, Robert, as you say, we need an umpire. I mean, it's all about checks and balances. That's the way that the Constitution was designed, so that you wouldn't have power residing in any one of the, of the legs of government, right?
Exactly. The Constitution sets up three major branches of the federal government, and then it leaves room for the states, which existed before the federal government. And the three branches are Article 1, Congress; Article 2, President; Article 3, the federal courts. And they're all supposed to be agents of the American people, to be working for the people. And the role of the court is, as you say, to be like an umpire, to call balls and strikes, and to make sure particularly that the other two branches and itself stay in the right lanes, that they carry out the duties the Constitution entrusts to them, but they don't encroach on each other's authority or on the states.
Exactly. Well, we're seeing, the court becoming more and more insignificant in this modern era. But there was, I guess, the original design of the court was that it was supposed to be quote unquote, the least dangerous, right?
Yes. When the people of the country were considering whether to adopt this then new Constitution in 1787, there was a set of papers written by founders, including Alexander Hamilton, that tried to explain to the voters, especially in New York State, what the Constitution would do, what changes it would make. And Hamilton said that he expected the judiciary to be the weakest branch. Now, it isn't really. It's co-equal with the others, but he had two reasons for thinking it would be the weakest branch. First of all, it couldn't enforce its orders. It would have to depend on enforcement activity by the presidency, by the executive branch. And second, it was supposed to be unpolitical, which meant it could be attacked by a president, by members of Congress, by Congress as a body, not really in a position to reply and defend itself. That would damage its integrity, its independence, its unpolitical character. So it had those two vulnerabilities.
Yeah, exactly. And the thing is, I'm sorry, go ahead, Robert. I'm sorry, I cut you off.
Over time, the American people have come to consider it legitimate and fair and independent and to respect it. So there are limits politically to how far its critics in Congress or the presidency can go.
Well, the long history of the Supreme Court, as you suggest, even in this current court, seems kind of even out things. I mean, when they can stay out of the political realm, it seems that that's when the courts is at its best. Is that fair to say?
Absolutely right. And one of the intentions, and I would say achievements of the current Supreme Court, which has 3 new appointees under Donald Trump, one of their great programs and achievements is to keep apart law and politics and to stay clear of politics, to leave that to the other 2 elected branches of the government and simply hold true to what the law requires, the Constitution and acts of Congress.
Robert, as an attorney, you and John both, I mean, this is what you've been living, breathing, and eating most of your life. Law, order, the Supreme Court as well. And this book is such a great asset, and I believe a blessing, to all Americans, because it helps bring into focus things that I'll guarantee you they didn't learn in school.
Well, that's very, very kind of you to say. I mean, both of us have taught constitutional law and practiced it. I began practicing constitutional law in 1986 when I went to work for the U.S. Department of Justice. That is where I met John Yoo. He is now teaching at Berkeley Law School out in California. I left the Justice Department in 2004 and went to work to teach at a law school in Minneapolis, University of St. Thomas School of Law, and I taught constitutional law there for 17 years. So we've both practiced it and taught it, and we've written about it extensively. This is our first book together about constitutional law, but we come from a deep background in the subject, yes.
Yeah. Well, Robert, address this dynamic tension in law schools amongst the judges, the difference between a constitutionalist a la the DNA of Nino, the justice that passed away, or more of an activist judge, by comparison, like RBG.
Oh, that's a really great question. Broadly speaking, there are 2 approaches to interpreting the Constitution. I mean, remember, the Constitution is a document, and documents require to be interpreted. And then if they stipulate laws, they need to be applied. So the 2 broad approaches are originalism and living constitutionalism. And the court, in our opinion, rightly, has been trending towards originalism for the past decade or more. And that is the view that when you read the Constitution and you read it, you interpret the words in the ordinary understanding they had when they became part of the Constitution. People debated, let's say, the First Amendment, the Second Amendment. They debated it. They understood it to have a certain meaning. They understood it to carry certain implications. That's the meaning that the courts should still give to that language in the Constitution. There's a process for changing the law, but if that process hasn't been used, then the law stays as it was at the time the language was adopted. The other view gives courts and the judges, who, remember, are not elected in the federal system, tremendous leeway to interpret the Constitution as they see fit in the light of their personal subjective values or their perception of the needs of the time. So it really empowers the judges to do broadly speaking, what they please within rather loose, self-imposed limits. And often it seems to me, in trying to update the Constitution to make it correspond to what they see as contemporary needs, they get it wrong. And they lock in an interpretation that, as things evolve, comes to be itself a kind of constraint, itself a kind of obstacle to meeting current needs.
Well, and I think that's what where we ran into trouble with, with Dobbs, Roe v. Wade, certainly affirmative action, and this is, I guess, where it's helpful to understand it. And you're so instrumental here, I believe, Robert, and I appreciate you coming on the show to help us understand this dynamic process that occurs in the court, in the Supreme Court, and filters on down, and this idea of originalism. And that's, I don't necessarily, I mean, I'm in terms of my understanding and where I like to land on the side of originalism. And I believe in the Constitution. Yeah. That is the standard. That's the first principle. You weigh the decisions, in alignment with the Constitution. On the activist side, the interpretive side, emotion, like you say, the realm of the day, and can influence an interpretation. But it seems that when we are more in that side, and I don't want to make one. There is that conflict, but I mean, the difference of the two is, I guess what I'm trying to say is that it seems that when we're consistent with originalism, the laws, the way they're interpreted, and the satisfaction by most of the people seems to be more in alignment with originalism than when a judge starts bringing in, some of their ideas that are outside of the boundaries of the Constitution. Is that fair to say?
I think that is fair to say. I mean, let's take an example from the Second Amendment. Now, you will hear people say, I've heard this quite a lot. Well, why should we accept the view of the 1790s about guns? Maybe people thought in the 1790s, when the Second Amendment was adopted, that there might be a British invasion from Canada. Nobody thinks that today. We should allow much more liberal gun control regulation. Well, let's look at the language of the Second Amendment. The key part, the operative part, says the right of the people to keep and bear arms shall not be infringed. Exactly. It's perfectly clear. And it means today what it meant in 1790s. There's nothing particularly arcane. You might dispute, well, should the people be understood individually or collectively? Or it's easy to interpret that language in a natural way. And by recognizing gun rights, you are actually keeping current with people's needs, because more and more we see law enforcement breaking down or not really being carried through as it should be. And people buy guns and keep guns in their homes in case of an emergency, in case they need to protect themselves or their families or their property. So the original language, the original public meaning of that language I quoted, and current needs mesh. And if you had judges deciding what the limits of gun control regulation should be and allowing enormous regulation, well, arguably the effect of that is to, disarm ordinary law-abiding citizens and allow the criminals to carry weapons and use them.
Well, and that clearly seems to be the case. I mean, when you look at the statistics, to back up your point here, you read the manifestos of these shooters who go in and kill people, and they're very specific about making sure that they find a place where there's a sense of, I guess, comfort on their end that they're not going to run into somebody else with a gun.
That's tragically the case, yes.
Yeah.
Yes.
And so exactly. So I appreciate you reminding us where we are, but again, being true to the Constitution, it clearly states that is our right, and this is why more and more states, Roberts, are just saying, look, you have a constitutional carry right. You don't need a permit. You don't need any other licensing or a special card to carry around. You're a citizen of the United States, and and thus you have every right to exercise your Second Amendment right.
Yeah. Now, there will be some limits, and there will be a role where the states and cities can regulate guns within some reasonable limits. The court has made that clear. It hasn't said that all gun control regulation is invalid, but in the cases before it, it thought the jurisdictions had gone too far. There's a case coming up next term, we'll see, about whether people who are serious threats of causing domestic violence and who have a record of gun violence can be barred of the right to use and keep guns. There are going to be questions, but broadly speaking, there is an express right to keep and bear weapons in the Bill of Rights, and
Exactly.
that has to be acknowledged.
Mm-hmm. Yeah, the fact of the matter is, again, true to our Constitution, we have a right to life, liberty, and the pursuit of happiness, and we have the self-responsibility and right to protect our property, because the Constitution was about, our property, our persons, our sense of peace, and the government is to ensure those elements for it, are they not?
Well, yes, and I would say that the current court has done a good job of protecting people's property rights. There was a case this term of an elderly lady from Minneapolis who didn't feel safe any longer in her condo. And so with the help of her family, she was moved into an assisted living center. She kept the condo, but she fell in arrears on her taxes. And after a couple of years, the city sold off her condo, which it had a right to do, and paid the debt that she owed in back taxes, but it kept the rest, which was her money. It said, we sold the condo for maybe, I think it was $45,000, and we kept your back taxes of maybe $25,000, but we're keeping it all. And so the court said, no, that's not your property. That belongs to her, and we're going to make sure that she gets it. So yes, that's in the Constitution. It's in the Fifth Amendment that the government cannot take your property, and that excess was her property. It cannot take it without just compensation. In this case, it was cash, so she got the cash.
Exactly. I'm for the lady. It was a great decision. We support things like that. It's like, the Bible says, when righteousness reigns, the people rejoice. So when things happen and the courts fall in line in ways that are consistent with the values of the heritage of this country, and lest we forget the heritage of this country, the woof and warp is so entwined in Judeo-Christian principles, right?
Absolutely. Yes, it is. Yes.
Well, regarding, I want to revisit the First Amendment right, because there were some decisions that came up in terms of freedom of religion and expression, and what we could do with our creativity and in the marketplace, and how we're not to infringe and be prejudiced towards others, but we're not to violate our conscience either. And I was grateful that the court protected our conscience in the process.
So am I. You're referring to a case called 303 Creativity, which came out of Colorado. It started out as a freedom of religion and freedom of speech case. The court severed the freedom of religion aspect, and it focused on the free speech. But the plaintiff, who was planning to stop a web design business, was a Christian. And she was afraid that if she started business, someone would approach her and ask for a web design for a same-sex wedding. And this involved her talent, her art, her creativity. It's like having a photographer do your wedding album. The photographer makes judgments about settings, about lightings, about what events deserve to be photographed. All of this requires judgment and expressive skill. And I think the same thing is true for a web designer. And it was not the case that she said she wouldn't serve gay or lesbian customers. If you wanted her to design a website for your widget and you told her you were gay, it wouldn't matter. And it also didn't matter if you were not gay, that you came to her for a website design that offended her religious faith. She was not going to work for people who wanted to tap into her expressive skill and artistry to do things that offended against her faith and her conscience. She won. This just caused an uproar, and frankly, I cannot understand why. This is absolute constitutional bedrock. You go back to the 1940s and you find the Supreme Court saying, the government cannot put words into people's mouths. It cannot make them say things that they find objectionable on grounds of conscience. If it's in the 1940s, school children in public schools who were Jehovah's Witnesses who could not take the Pledge of Allegiance because they thought that was worshiping Caesar and not God. It's just too bad for the public school districts. They cannot make those children swear out something that is against their conscience and their faith.
Well, we've got to hit the pause button here right now. Robert, forgive me. We got to go to break. We'll pick it up on the other side. More from Robert Delahunty after this. Stay with us.
Do you have heart failure and often hear,
"Those stomach issues ruined your birthday"?
"You're too tired to play catch, Grandpa."
Sweetie, you haven't touched your tools since the carpal tunnel syndrome diagnosis.
If these seemingly unrelated symptoms sound familiar, talk to your cardiologist. Ask about transthyretin amyloid cardiomyopathy, or ATTR-CM, a rare and underdiagnosed disease that gets worse over time. Learn more at connecttoyourheart.com. That's connecttoyourheart.com. Sponsored by Pfizer.
How would you like to get high-speed internet for your home for less than $2 a day? That's right. For about $50 a month, you'll get lightning fast internet. Are you paying less than $50 a month right now for your internet? Then call Whole Home Connect right now for blazing fast internet at $50 a month with no price increases, no hidden fees, no contracts, no upfront costs, no equipment fees. It's a great deal. And guess what? You can try it for 15 days. If you don't like it, you get your money back. But you're gonna love it, and you're gonna love the price. Internet for your home for $50 a month. That's less than $2 a day. Plus, no contracts, no upfront costs, no equipment fees, and our 15-day guarantee. Call now. 800-699-0358. 800-699-0358. 800-699-0358. That's 800-699-0358. How would you like to get high-speed internet for your home for less than $2 a day? That's right. For about $50 a month, you'll get lightning fast internet. Are you paying less than $50 a month right now for your internet? Then call Whole Home Connect right now for blazing fast internet at $50 a month with no price increases, no hidden fees, no contracts, no upfront costs, no equipment fees. It's a great deal. And guess what? You can try it for 15 days. If you don't like it, you get your money back. But you're gonna love it, and you're gonna love the price. Internet for your home for $50 a month. That's less than $2 a day. Plus, no contracts, no upfront costs, no equipment fees, and our 15-day guarantee. Call now. 800-699-0358. 800-699-0358. 800-699-0358. That's 800-699-0358. If you're living with diabetes and using insulin, you know the pain of pricking your fingers over and over again. Ouch! Well, by wearing a small remote device called a continuous glucose monitor, or CGM, you can reduce the pain of pricking your fingers. If you administer insulin 3 or more times per day or use an insulin pump, call now and learn how a CGM can help you.
Painless. No more pricking my finger.
No finger pricks.
Convenience. They delivered it free and they took care of all the paperwork.
You can reduce pain right away. Plus, it's accurate, easy to use, and helps you spend more time in range. And if you have insurance, you can get a new CGM at little or no out-of-pocket cost. Call now and get free shipping of your new CGM. Plus, we'll bill your insurance for you. 800-823-9853. 800-823-9853. 800-823-9853. That's 800-823-9853.
Well, some would say that the Supreme Court decisions recently were controversial. But when you look at it, and certainly the polling on this, Robert Delahunty, would suggest that the majority of Americans sided with the Supreme Court and thought their decisions about affirmative action, big tech, social media, and the First Amendment that were decided this summer was a good thing for this country. The Politically Incorrect Guide to the Supreme Court by John Yoo and Robert Delahunty, our guest right now, is becoming the go-to guide to breaking down everything you need to know about SCOTUS, past and present, to be the informed American who can see the truth, make a difference. It's written by law professors devoted to defending the Constitution. Readers are going to gain trustworthy expertise. Trust me, it really is, you see, as you read this book, you have this sense that, okay, I'm starting to get it. The right bricks are falling into place. And I got to tell you, Robert, in reading your book, it reinforced, at least in my heart, in my mind, the love for our Constitution and the brilliance and the divine hand of God that was upon our founders in putting this document together.
It is a magnificent document. It's priceless, and it has shaped the course of the history of the American people, and it has helped to ensure that this country for so long has remained free and prosperous and powerful. Mm-hmm. Bill, you mentioned the polling about the recent Supreme Court decisions this term, and it's an interesting question, interesting point. Mm-hmm. The Supreme Court, obviously, to be independent, to be above the political fray, cannot be guided by the polls. Otherwise, we wouldn't need a Supreme Court. We just need Pew or Gallup. But it is interesting that this term, the polls show a very clear popular support for its decision on affirmative action, the Harvard or University of North Carolina case. And it's interesting, one poll I saw said that there was a 20-point spread between those who favored the decision and those who opposed it. Mm-hmm. That's a very significant spread. But it's consistent with findings over years and even decades that most people do not approve of racial discrimination and admission to higher education. And what is equally interesting, I think, is that a poll I read yesterday or the day before showed that the majority of African Americans also approve of the Supreme Court's decision in the Harvard case. It's basically the law of the land that in this country, the government has to be colorblind. It cannot take account of your race in giving out benefits or in imposing burdens. Let me give you a simple example. I think it's intuitive, but it makes the point that really the Supreme Court was trying to get at. Suppose you're waiting to get a driver's license at the Department of Motor Vehicles, and as usual, it's extremely crowded, and there are long queues to get to the counter, and when you get to the counter, they say, go to the next counter. We can't help you here, okay? So suppose one of the clerks comes out from behind the counters and points to the third, seventh, and 28th person waiting in the queue that's 200 long and says, you all come over here, I'll give you fast service because of your race or because of your ethnic background. Mm-hmm. How fair is that?
Exactly.
Who thinks that that's the American way of doing business? It isn't. And it hasn't been since the 14th Amendment was ratified after the Civil War. Now, in practice, have we lived up to that promise, to that law? No, we certainly have not. And that, as the book shows, was largely the fault of the Supreme Court of the 19th century. But as a society and as a legal system, we have been making a fundamental course correction. And this decision puts the seal on that. It says, as far as the government goes, your race is immaterial. It should not be a factor in the decision-making of government universities or of those that receive funds from the federal government.
Exactly. Robert, I think this is such a huge victory for humanity I mean,
is.
that's what we all want. We want the freedom to be the best we can be, to be judged, as Martin Luther King said, not based on the color of our skin, but on the content of our character. I mean, and people often use that, but, you have to believe it. And I think that what the Supreme Court did was kind of turn a light back on the truth and on those things that would greatly benefit the citizenry. And I think it was just a huge victory, for those of us who have lived by the code of hard work and commitment to having a fair chance to win. We love this country because of the opportunity that is before us. This is why so many millions of people are dying literally to get into this country, illegally included, because it still is that light, as John Winthrop declared, on a shining hill. It's that beacon that goes forth and says, liberty resides here, but we need to protect it and understand that liberty is a full circle, just like what we're going through here with affirmative action. It's a full circle. You go through the experiences, like I share with my kids all the time. I said, experience defines preference. And I believe the country has gone through the experience of what affirmative action did. They knew it was a little rough to begin with, that it wasn't going to hold water. It was kind of a Band-Aid, application. It was not going to, really heal the problem. But thank God, it's like through the experience, we've come to that point to realize that, we've got to have a level playing field. Let everybody go and, be the best they can be and be measured on merit, not on the color of their skin or their sexuality.
Exactly. I mean, Justice Scalia some years ago said, and again, in terms of the government, in this country, we have one race. That's American. Right. Now, you can be, and you should be, and we encourage you to be, have some other ethnic or racial identity too. But in the eyes of the government, there's one race here, which is the American race, the American people. And we all understand that some racial minorities have serious educational deficits, but I don't think that they are fixed at the college level or at the level of Harvard or UNC. They're fixed. And this is the point Justice Ginsburg made in her opinion in the Grutter case in 2003. It's a liberal point as well as a conservative point. You cure the deficits by looking at the quality of education from K through 12. You don't kick the can down the road. Right. In the Grutter case, the court said we're going to sunset affirmative action 25 years from now. Okay, well, it's 20 years. But as an experiment, the court seemed to think as a social experiment, it was not succeeding. It was not creating sustainable rates of minority admissions that could hold true if you drew the preferences. So, and that all makes perfect sense, both as a matter of constitutional law and as a matter of social policy.
Robert De La Hunte, we touched on this a little bit, and we've got a couple of minutes left in this segment, and I wanted to address, this tension between, an impartial Supreme Court and the rise of the administrative state that's really pushing on these decisions, right?
It is. And this is where I think in the next term or two, you're going to see the most controversy and the most interest in what the court does. I mean, we have a problem with Congress, which often wants to pass the buck and doesn't want to make controversial, politically costly decisions about national policy, let's say particularly environmental policy. So they write statutes that are completely meaningless, and they hand off the decision-making to administrators. Or they write statutes that are self-contradictory, and they leave it to the administrators to figure out what to do. And this is not a good way to run a railroad. I mean, we elect people to Congress to make these tough policy calls, and we don't elect federal bureaucrats. And so one thing the court has started to do is to cut back on that and to say, if we're going to have a forgiveness of $420 billion, let's say, in student loans, that's got to be decided by Congress. At least it has to authorize in clear language an agency to do that. Otherwise, we don't really have our constitutional system or democratic values.
Exactly. Well, we've got to go to break. We'll pick it up. We've got more to talk about. It's especially looking ahead. Where do we go, from here? And we're privileged to have the constitutional law professor, Robert De La Hunte, with us. And our conversation will continue after this.
Thank you.
Has your heater or air conditioner busted? Appliance broken? Computer crashed? Then you need an ARW home warranty. Home system and appliance repairs and replacements can cause stress and cost you thousands of dollars per year. With an A-plus BBB rating and a top-rated home warranty company on Consumer Affairs and Trustpilot, ARW Home provides superior service, featuring the industry's lowest service call fee. ARW Home has warranty plans that cover your kitchen and laundry appliances, heating and air conditioning systems, electrical and plumbing systems, and much more. Call 800-559-7562 to customize your plan. Plus, ARW has partnered with Azurian to protect your new and used tablets, laptops, TVs, and other home tech from accidental damage and wear and tear. All plans come with a 30-day money-back guarantee. Call 800-559-7562. That's 800-559-7562. How would you like to get high-speed internet for your home for less than $2 a day? That's right. For about $50 a month, you'll get lightning-fast internet. Are you paying less than $50 a month right now for your internet? Then call Whole Home Connect right now for blazing fast internet at $50 a month with no price increases, no hidden fees, no contracts, no upfront costs, no equipment fees. It's a great deal. And guess what? You can try it for 15 days. If you don't like it, you get your money back. But you're gonna love it, and you're gonna love the price. Internet for your home for $50 a month. That's less than $2 a day. Plus, no contracts, no upfront costs, no equipment fees, and our 15-day guarantee. Call now. 800-699-0358. 800-699-0358. 800-699-0358. That's 800-699-0358.
I am a non-attorney spokesperson representing a team of lawyers who help people that have been injured or wronged. Have you been diagnosed with cancer? Do you use pesticides in your job? Specifically Roundup. Roundup, made by Monsanto, contains a chemical called glyphosate, which has been linked to cancer. If you've used Roundup and you have cancer, you may be entitled to a cash award. Over $10 billion has been set aside to pay users of Roundup who've been diagnosed with cancer. Time is almost running out to file your claim. So if you've been diagnosed with cancer and you've used Roundup, call the legal helpline now. You could receive a free cash award and have your medical expenses covered. And time to file is almost gone, so please call right now.
800-890-7088. 800-890-7088. 800-890-7088. That's 800-890-7088.
Hey, thank you for being with us. I'm Bill Martinez. I got an interesting email from a viewer the other day. Said, Bill, I noticed that, you have this campaign going for truth and liberty. Can I donate, with a tax, for a tax deduction? Absolutely. Our show's a nonprofit entity. It's under Hill of Hope. It's a 501c3 public nonprofit organization. So all donations that you contribute to the show in our campaign for truth and liberty can be tax deductible. So, if you've got some, end of the year, some IRS issues and you need a tax deduction, we're happy to be there to serve you in any way possible to make things a little bit easier. So by all means, check it out. Go to BillMartinezShow.com right there, hit the donate button, and we thank you in advance for however God should move your heart or however you should need to use us for income tax purposes, and that we're happy and here to serve. Robert De La Hunte, the constitutional professor, continues with us. We're talking about his brand new book. He and John Yoo have blessed us with. I say it is a blessing because this is something that you haven't learned in school, And probably there's too many attorneys, Robert, I would dare say, that could benefit from this book. It's a quick read. We know we have a lot of attorneys that are participating in the legislative branch of our government. They have a hard time reading the bills that are presented because of the administrative state and I guess the laissez-faire attitude about their responsibility to make sure that they read the doggone bills. I mean, it's just amazing to me. But maybe this will be a quick enough read for them and a good refresher, for them to realize, the job, the outstanding job the Supreme Court has done on our behalf. In conclusion, in your book, and you say going forward, you see a turning point. And I think that there has been an adjustment, especially in this current court. And I can understand some viewers might say, well, Bill, you're conservative and you kind of like the way the things are coming down right now. And I get that. And I don't want to be happy at the expense of your misery. I think that we need to come to a point and understand that the levers of our government should work for all Americans. As Robert had said earlier, this is about America. This isn't about the Republican Party, the Democratic Party, or independents. This is about this great American idea that our founding fathers put into motion, and they gave us these beautiful documents, the Declaration of Independence and the Constitution, which is our roadmap to life, liberty, and the pursuit of happiness. So, Robert, here we are, 247 years later. We've had some course adjustments. I see it as being positive. I'm hopeful for the court. I'm hopeful for America, because hopefully through these adjustments that have been made, that we, the people, can see the benefit of it. What do you say?
I agree with all of that, Bill. Let me just make one point about conservatism. There's political conservatism and there's judicial conservatism. The Supreme Court should not be politically conservative, and I think it is making an honest effort not to be. This term, it came down with several major decisions that actually, in the view of commentators, tend to break in favor of the Democratic Party, including a voting rights decision in Alabama, which may create an additional African-American dominated congressional district in Alabama.
Right.
That's what the Supreme Court did. Judicial conservatism is something else. Again, it requires you to read the Constitution according to a certain method, which we've discussed, originalism. That can give you results that are actually pretty liberal in terms of social policy. Or let's take abortion. You might completely agree with the Supreme Court's decision in Dobbs that abortion is not in the Constitution, but still be a pro-abortion activist in your state, right? And there's a difference there between legal and political conservatism. And we want the court to be legally conservative. Whether it's politically conservative or not, that's not its job.
Right. Well, I think that sometimes people look to the court like when they were growing up. If you didn't get the right answer from mom, you ran to dad, right?
Right,
and,
they do.
And conversely. And it's like, wait a minute,
Yes,
we need to grow up. That's not what the court's here for. The court is not your mommy and your daddy, right?
No, it wants to keep the branches of the government and the states in their right lane. In the student debt forgiveness case, for example, the Chief Justice actually said something very close to that. He said, we're not here to decide whether student debt forgiveness is a good policy or a bad policy. There are dozens, if not hundreds, of bills before Congress. They make the policy call. What we do is route the traffic. We keep the branches of the government in the right lane. It's not for the executive branch alone to make this decision. It's for Congress working with the executive branch. It's really our decision. We decide. It's a second order decision. We decide who makes the decision. We don't make the decision.
Exactly. Well, and I think that, when you hear some legislators like AOC, for example, really demonstrate their ignorance, and it inflames people. It gives people the wrong information. It's interesting, the sensitivity of social media and the mainstream media and trying to somehow become traffic cops for misinformation. I think when they try to manage it, they actually end up doing just the opposite of what's intended.
Speaking about her and members of Congress like her, and some are on the right as well as on the left, one of the big problems we have with Congress is that we have too many show ponies and not enough workhorses.
Amen.
If they were less interested in grabbing headlines and more interested in doing the work in committee rooms to work out differences and come up with compromises, this country would hold a lot better run.
Yeah, could you imagine? They just did their job, Robert, what you're saying.
That's
exactly.
What they should do, yes.
Yeah.
Yes.
Yeah.
Right.
And this idea, if you don't get your way, then I'm going to threaten you with court packing, or we're going to come after you and impeach you and go through all this stuff. I mean, how does that serve the people?
One of the priceless things we've had in this country is a history of independence of the courts from the political system. And that has helped ensure that we remain a free people. In the entire 200 and how many years did you say? 47?
47 years and counting, yes.
Our Constitution. There's only been one Supreme Court justice who was impeached, and he was acquitted, and that was 1803, I think. So we have people on the court in the past and now who are honorable, who have integrity, who are smart, who are hardworking, whatever their political or legal positions may be. I trust them all. And I think that we should all wish the best and commend it when they stand fast in their views, even when they're threatened with demonstrations in front of their homes, threats to families, or in one case, an assassination attempt.
Exactly.
God bless them for being brave enough to stand up for all of us.
And the rhetoric has to be tapped down significantly. Absolutely. You can't have the leader of the Senate yelling from the steps of the Supreme Court in a threatening manner. And
absolutely not. It's shocking.
And to have statements thrown across the bow. Look, I understand you may not agree with the decision, and there's a way to do that with a sense of civility. The rhetoric has gotten so dangerous that people start acting on it, and they feel justified because of the contribution of this very loose language, very dangerous language that's going out there. Now, I understand that may run the edge of freedom of speech. You have the right. You can go ahead and it's your choice. You can be an idiot if you want to, but I just would caution, those that are the viewers here, that it's okay. Emotion is a good thing, but we don't want it to get to the point where it violates the principles and violates, the desire and the peace of mankind around you, if that makes sense.
It does.
Yeah. Well, we've got about just about 3 minutes left here, Robert. I want you to kind of sum things up and in the context of what would our founders do right now? You address this in the book. What would the founders do?
Well, there's a pretty long road back, I would say, from where we are to get into a constitution that they would recognize as the one they made. Yes. But in the last several years, I think the Supreme Court has traveled a good distance down that road, the road to recovery, let's call it, and I see signs of progress ahead. I think next year, they're going to be handing down maybe 3 major decisions about the administrative state. And I hope and expect that they will turn out well and that they will restore power to Congress where it belongs instead of leaving it with the federal bureaucracy. I think they will give us a better definition of the extent in which jurisdictions can regulate guns. There is, as I mentioned, this gun rights case. I don't know that there's anything currently on the docket, but they may have to take up in the next year or two some abortion-related cases, not about a right to an abortion, but what states can and cannot do, especially when their citizens travel out of state to have an abortion or buy drugs through the mail and bring them into the state. These are all issues that I think are up for decision in the next couple of years. But what would the founders say? Well, of course, they'd be very proud to see how well the Constitution has lasted. We've survived a civil war, and we've survived 2 world wars. So there's reason to hope. But it's going to take work, and it's going to take work by all citizens. And people need to read and think and debate and enjoy the given freedoms that we have.
Exactly. And as we're often saying on this show, Robert, you got to own your own knowledge. Don't just take my word. Don't take Robert's word. Yes, he's a constitutional professor. It comes with a lot more credence than Bill Martinez. But we should not be the last word in this. It should come out of you. It's how you interpret it. It's you being motivated enough. And hopefully that's what this conversation has done. It's motivated you to say, you know what? I'm going to look into it. Okay, so forgive your teachers. They didn't give you the right education. Maybe when it came to the Constitution and civics and that, maybe you missed out. But you know what? Today is today. And you can be the difference. You can be that informed voter, that educated participant, that citizen in this country that really what we the people is all about. We the people is us. We can't go on blaming Joe Biden or anybody else, right, Robert? I mean, really, the government that we have right now, it is on us. I'm going to give you the final word as we wrap things up right now, Robert. Go ahead.
Well, I mean, that's ultimately the purpose of this book, to help to make people informed citizens and informed voters, and to use their minds and to use their mouths and to speak not just out of their heads, but with information, with thought. I'm not looking for agreement. I used to say that to my students in the class. You can think what you want. You better have good arguments and you better have logic. That's what we're trying to do.
Amen. Well, that's great. Well, congratulations to you and John Yoo on the book. These are constitutional professors, and we're blessed to have Robert Delahunty on the show. His book, The Supreme Court, The Politically Incorrect Guide to the Supreme Court, from John Yoo and Robert Delahunty. Robert, thank you so much for being with us.
Bill.
That is a wrap for us. Thank you for joining us. For more information on the show and to be a part of this mighty Martinez movement to return to God and to save our country, check it out, BillMartinezShow.com. May God bless you and keep you and make his face shine upon you. Go and be blessed beyond your imagination. Thanks for joining us. Take care.